So let's listen in to the arraignment of Sherwin Moore.
Cooperated in some form of investigation there. As we all now know, defendant was at some point on Wednesday afternoon fired from his employment. He then, at some point soon thereafter, came to her apartment in the address that is alleged in the complaint, barged his way into that apartment, immediately then proceeded to a kitchen drawer, grabbed several butter knives and a pair of kitchen scissors, and began to threaten his own life. I'm going to kill myself. I'm going to make you watch. My blood is on your hands. You ruined my life. And a series of very, very threatening, intimidating, terrifying, quite frankly, statements and behaviors there in that apartment. It was only then, Your Honor, when the victim, she called her attorney and then at some point indicated she was going to call the police, and then he left. And so, Your Honor, while I understand that there isn't evidence to suggest that he directly threatened the victim with any of those implements that I've indicated, the totality of the behavior is highly threatening and highly intimidating. She was terrorized, Your Honor. And in light of the totality of all of those circumstances, we consider the defendant to be a risk to public safety, a risk to this victim, and it is for those reasons that we are asking for those specific conditions. I am more than happy to answer any other questions that the court may have or give you further information, and I appreciate the opportunity. Thank you, Judge.
Simon has the button.
Your Honor, let me start at the end where the people ended. In terms of risk to public safety, my client's 39 years old with zero prior criminal history, zero prior contact with the criminal justice system in any fashion. The threat to public safety argument by these charges, maybe that's the point, but there's no evidence to suggest that he's a threat to the public safety. The next thing is that the people referenced the court rule that I want to come back to, that you can't deny bond in a situation like this, and they referenced something else that I want to come back to, which is the fact that they reviewed thoroughly the police report, and they reviewed thoroughly the body cam. I've had none of that opportunity. And not too early for that in the proceedings, so when people come here and make factual representations, although I trust Ms. Mirsky very much as an officer of the court, I have no ability to respond to those factual representations. So here's what I'm going to ask the court. The monetary bond component, the two considerations by court rule are my client will appear. Let me speak to that. He's got a home here. His family is here. He's got ties to our community. He's retained a local counsel here. Second thing is that my client is not otherwise a danger to the public or danger to the complainant. That is why monetary components are requested, but there are other measures to address them. For example, the request for a GPS tether, that was an expected request. My client will gladly comply with that request. The second thing is my client having no contact. Revoked. In terms of surrendering the transport of passport, Your Honor, there's no really indication that he is a flight risk. My client has those established ties that I talked about. But in addition to that, Your Honor, he would have an order from the court, like everyone else does, that there would be no leaving the state, let alone the country, without permission of the court, and he would certainly abide by that. Your Honor, with respect to the request for a mental health evaluation, I will represent a few things that are my understanding, again, without being privileged to have reviewed discovery. My understanding is that following his arrest, my client was taken to the St. Joseph Mercy Health System for an evaluation, a mental health evaluation. My understanding is following that evaluation, he was not turned over for a commitment, but instead turned back over to law enforcement for lodging. That's where he's been at the Washtenaw County Jail sits. I can also tell the court that the Community Mental Health Department saw my client yesterday for an evaluation as well without any further recommendation. If you make that a condition of bond, I can tell the court that he get a mental health evaluation. He will absolutely comply and follow any aftercare recommendation. Lastly, Your Honor, with respect to the bond amount, I forgot to speak about weapons. He has no weapons, but he'll surrender. If you order that he surrender any weapons that he doesn't have, he'll be glad to comply with that condition. With respect to the bond amount, Your Honor, in a case like this, with charges like this, in a normal circumstance, we'd be requesting a personal recognizance bond and frankly expecting the court to order that. We all know this is not our ordinary circumstance. It's not an insignificant amount of money to anyone. And I ask that the court set the bond amount to the principles not of my client's bank account, but to the principles of the charges and to the principles of the court rule. Therefore, I'm requesting that if the court orders a monetary component at all, that it be with a $25,000 10% privilege. And also, Your Honor, if my client is to order to a GPS tether, things have to happen pretty significantly to try to get that in place in time for what we hope to use in this day. Thank you.
Mr. Moore, could you state your name, please?
Ron Moore.
So you are not to use alcohol, marijuana, or any other controlled substance that is not prescribed to you. You are not to possess or purchase a firearm or any other dangerous weapon. You are not to engage in criminal conduct of any kind whatsoever. You may not leave the state of Michigan without permission of the court. Prior to your release, you will be placed on a GPS tether. You will not be released before that GPS tether is placed upon you. You must continue all mental health treatment as a condition of your bond. The named victim in this case will not be placed on the record. You may not have contact with that individual. That means no calling, no writing, no video chatting, no texting, no emailing, or any other form of contact the human mind can possibly fathom. No one in the world thinks that this person is going to reach out to you. Should they do so, and again, no one thinks that they're going to, you may not reply in any form or fashion. The named victim's address will not be placed on the record, or you may not go to that location for any reason whatsoever. Are we understood on the no contact and no go-to, sir?
Yes, Your Honor.
If you have any questions about that, you have a good attorney, simply ask them. Do you understand?
Yes, Your Honor.
Bond will be set in the amount of $25,000 cash surety, as requested by the prosecution's office. This court does not determine innocence or guilt. This court determines flight risk and community safety. The court finds with these conditions in place, it has been met. Mr. Simon, we are setting probable cause conference at this time for January 8th due to the holidays and scheduling. Is that a good court date for you?
Your Honor, my client will wait.
It has been met. Mr. Simon, we are setting probable cause conference at this time for January 8th due to the holidays and scheduling. Is that a good court date for you?
Your Honor, my client will waive his right to have that next court appearance within 14 days. I've discussed that with him. I also try to coordinate calendars with Ms. Rasmirsky. In support of that, I think we're both available on January 22nd, if the court would order that. And I'll add one more thing for the record in support of that. I understand there is continuing investigation. So in addition to the discovery I don't yet have, there may be even more. So
it will be January 26th, 2020.
22nd, 15, 22nd, 21.
22nd, Thursday.
January 22nd, then. January 22nd, 2026, 9 a.m., 14A1 District Court, Courtroom C. That will be in person. Sir, do not violate these bond conditions. Follow all orders of the court. Stay in contact with your lawyer. That concludes this hearing.
Thank you very much.
We have been watching the arraignment of ex-Michigan head football coach Sherrone Moore, now charged with felony home invasion and 3 misdemeanors related to his arrest. A judge determining that he is not a flight risk nor a danger to the community should he follow the conditions that were set out as part of his release. Bond is set for him at $25,000. The prosecution argued that hours after he was fired, Moore barged into the victim's home, went into her kitchen drawer, grabbed knives and scissors, and then threatened his own life, allegedly saying, "You ruined my life. My blood is on your hands." Apparently, at that point, the victim called police and Moore left. The totality of the behavior, prosecutors argued, is highly threatening. The judge there siding with the defense that made the case that there is no evidence that he's a threat to public safety. We have Whitney Wild with us, who's been tracking the details of this case, as well as former state attorney for Palm Beach County, Dave Ehrenberg. We'll get the legal perspective in just a moment, Dave, but Whitney, your takeaways from this arraignment.
This is the first real detail we have about any of this that occurred 48 hours ago, Boris. We just dipped into it, but again, I'll just catch our viewers up to speed. As you said, it certainly sounds like this was Sherrone Moore's reaction to having been fired. Hours after he was fired, and we know that it was because he had an inappropriate relationship with a staff member, he barged into a victim's home. Again, he was, according to the prosecutors, his behavior was highly threatening. It was highly intimidating. He told the victim, "You're ruining my life," indicated that he said something to the effect of, "I'm going to kill myself." After the victim called her attorney and then indicated that she would call police, according to the prosecutor, he then left. What the prosecutor was saying to the judge in trying to get the most stringent bond restrictions possible here is that the totality of the behavior is highly threatening, highly intimidating. And the word that the prosecutor used was she was terrorized. The prosecutors did consider the defendant a risk to public safety. And so, again, they were asking for specific conditions here. The defense arguing that he has a family here, he has a home here, he has no criminal record, no contact with law enforcement, no contact with the criminal justice system. And so really this is a specific incident, poses no further risk to the community. And the judge laying out very specifically the conditions of the bond. No contact with the victim. Even if the victim attempts to contact Sherrone Moore, he is not to respond. He is now going to be placed on a GPS monitor. As you said, $25,000 bond. His next court appearance is January 22nd. We will see if more court records come out. We have requested 911 calls. We've requested a more detailed police report that may give an even more detailed narrative about what happened. But so far, Boris, these are answers that I think everybody has been waiting for over the last 2 days once news broke that Sherrone Moore was fired and that he was later arrested. Boris?
Yeah, really a stunning turnaround if these allegations turn out to be true. Whitney, please stand by. Let's go to Dave Ehrenberg. Dave, what is your reaction to hearing this? Obviously, outside of the fact that he had such a high-profile job and that so many our producers are telling me that his attorneys are coming out and speaking to reporters. Let's listen in.
I'm just going to not answer that question, but he'll be in the community.
Tell us about this. What's the mood of your client right now?
Listen, that is something that I will also not comment on, but I will say you heard that there was a condition of bond for him to have mental health counseling, and we expect that too. Okay?
Do you have any comment on the allegations?
None. And I said in court, I've not seen a police report. I've not seen any other discovery. It would be irresponsible to comment, so I won't.
How's he doing mentally? Is he saying anything?
Yeah, so I'm, again, not going to comment on that. Thank you very much, but I do need to get through you guys. Okay. Thank you.
Joe Simon there, the defense attorney for Sherrone Moore, choosing not to comment on a number of questions, specifically about the well-being of his client, saying that he won't dig into the details, but as part of his release, the condition is that he will continue with mental health counseling, notable given some of the allegations about suicidal remarks. David, just stepping back, as I was saying a moment ago, remove from the equation the fact that this is a high-profile individual whose firing was obviously newsworthy. Do you think that the stipulations set forward by the judge, this $25,000 bond as well as these conditions, are appropriate for the charges that he's facing?
I do, Boris. It's pretty normal. These are serious charges. One of them is a felony, but he's a first-time offender. He is really not much of a flight risk. I mean, he's pretty well known. He has ties to the community. he's more of a threat to himself than to others. And so I do think that the bond conditions are appropriate. We need to make sure he is nowhere near the victim, does not try to communicate with her. And if he does, he'll be locked up immediately pending trial. My biggest takeaway was learning that when he got the knife, he did not use it to threaten the victim. He used it to threaten himself. That's why you don't see more serious charges of aggravated assault with a deadly weapon or more aggravated home invasion charge. This is just third-degree home invasion, which is, even though it's serious, it's the lowest level felony. And it could be punishable by up to 5 years in prison, but he is a first-time offender, so he would likely get nowhere near that.
What do you imagine the defense is going to argue on his behalf? Do you think it's likely that perhaps they come to some arrangement with prosecutors and this thing never goes to trial?
Yeah, very possibly. First-time offender, someone who has mental health issues, someone who threatened himself, not another person. That's key. And I think that if the victim agrees, that you could see a plea deal where he has probation and mental health treatment and ends up serving no time in jail or prison. I think that's actually a possibility. So we'll see how it plays out. But right now, he's a subject of worldwide ridicule, humiliation, which is punishment in itself. But ultimately, I think the victim's wishes will be important here because she's the one who allegedly has been stalked and has been perhaps threatened in the past. And she needs to tell the prosecutors which way to go on this.
To that point, the school has been investigating this alleged inappropriate relationship, or what they say is a confirmed inappropriate relationship, since October. And its investigation into the handling of this relationship is currently being done by an outside law firm. In other words, it's still possible that more details may come forward related to this relationship and his firing. Do you see that as potentially impacting this case in the form of new charges, perhaps?
I think where it's impactful, Boris, is in a potential civil lawsuit against the University of Michigan. Wow. How long do they know about these issues? According to reports, they were notified back in September that this affair had happened, and they allegedly slow-walked it. They waited to fire him until after the commitment date was over, the national letter of intent date where high school students commit to the University of Michigan. And so were they waiting until the season was over, until they found out if he would beat Ohio State in football? Because if it's true that they knew about this months in advance, and if they knew he had severe mental health issues and then fired him as soon as the national commitment day was over and just fired him without counselors there, just let him out into the wilderness, then they could really be hit with some serious lawsuits.
Yeah, it would be significant, also considering some of the scandals that Michigan football has faced in recent years, some of them involving Sherrone Moore. We have to leave the conversation there. Dave Ehrenberg and Whitney Wild, thank you both so much. We'll, of course, stay on top of this and bring you any new developments as we get them.